Have you ever wondered what happens to a person's assets after they pass away, especially if they were married? It is a question that touches many lives and can have significant implications for those left behind. Understanding this topic is incredibly important for financial stability and peace of mind. When a spouse passes away, the surviving spouse generally has specific inheritance rights, which can vary significantly based on state laws and whether a valid will exists. These rights are designed to protect the surviving partner, ensuring they have financial support and a share of the marital assets. In many places, laws are in place to prevent a spouse from being completely disinherited. The core mechanism behind these rights often involves state laws regarding wills and estates. Most states have what is known as elective share or spousal share statutes. These laws allow a surviving spouse to claim a certain portion of the deceased spouse's estate, even if the will tries to give them less or nothing at all. This share is typically a fraction, like 1/3 or 1/2, of the estate, and it can sometimes include assets that pass outside of probate, such as certain trusts or jointly held property. Community property states, found in some parts of the country, treat assets acquired during the marriage as jointly owned by both spouses, meaning the surviving spouse automatically owns half of those assets. Conversely, common law states have different rules, usually relying more on elective share provisions to provide protection. To understand your specific rights, the most important step is to consult the laws of the state where the deceased spouse resided and to review any existing estate planning documents. If there is a will, it will outline the deceased spouse's wishes, but remember that state laws like elective share provisions can sometimes override those wishes. If there is no will, which is called dying intestate, state intestacy laws will dictate how assets are divided, with the surviving spouse often receiving a substantial portion, if not all, depending on whether there are surviving children or parents. It is also valuable to know about spousal allowance laws. Many states provide for a temporary living allowance for the surviving spouse during the estate administration period, helping cover immediate living expenses. Furthermore, homestead exemptions can protect the family home from creditors and often allow the surviving spouse to continue living there for life. These protections highlight the legal system's recognition of the family unit's continued needs. Understanding these nuances can make a significant difference in navigating a challenging time. By grasping the fundamentals of state inheritance laws, elective share provisions, and the implications of having or not having a will, surviving spouses can better assert their rights and ensure their financial well-being. Proactive estate planning is always the best approach, but knowing these protections offers a vital safety net, allowing you to focus on healing and moving forward with greater confidence.